Good morning. Welcome to House Judiciary for February 5th. Pierre, will you call the roll?
Representative Brady,
Here.
Representative Breton,
Here.
Representative Chestek,
Here.
Representative Filer,
Here.
Representative Kelly,
Here.
Representative Lean,
Here.
Representative Singh,
Here.
Representative Webb,
Here.
Chairman Washek.
Here.
You have a quorum.
Thank you. So this morning we have what's sometimes referred to as a zombie bill. I prefer to use the term Phoenix bill. As you see a bill rise from the ashes to come back to us again. And I thank the sponsor for her efforts on House Bill 329. So with that, why don't you tell us what we need to know?
Thank you, Mr. Chairman. And committee members, my name is Laurie Bratton, and I'm the representative for House District 51 in Sheridan. I'm here to introduce House Bill 329, the Office of Homeland Security Amendments. As the chairman said, this is a Phoenix bill, or a rewrite, as we say in rodeo. If you'll recall, earlier this session, this committee heard a bill that would allow the state of Wyoming's Office of Homeland Security to request and have access to information from the Wyoming Department of Criminal Investigation, or DCI. Some legislators had reservations on that bill due to an existing statute that required the Wyoming Department of Homeland Security to fully cooperate with the Federal Department of Homeland Security, as well as other state departments of Homeland Security. As a result, that bill was defeated in the House. I immediately began looking for a more narrowly focused approach to the issue that the Wyoming Office of Homeland Security was facing. That is, having statutory permission to get pertinent information from the DCI when needed to perform the functions of their office. With the assistance of our legislative services team and in coordination with the director of the Wyoming Office of Homeland Security, and through her, the director of DCI, I'm here to present this bill, House Bill 329, the Office of Homeland Security Amendments, as a solution. There are essentially three elements to this bill, so I'll walk you through the bill. The first element is on page 2, lines 5 through 6. The bill would add the Wyoming Office of Homeland Security to 9-1-616. And this existing statute, subsection A, is the current statute that provides DCI with the ability to cooperate with federal, state, tribal, and law enforcement agencies. This part of the bill would add the Wyoming Office of Homeland Security to that list. So that was what was part of the bill in 50. For the second element of this bill, skip down to the bottom of page 2, lines 22 and 23, and carrying on to page 3, lines 1 and 2. This creates a new subsection E under 1913-105, which provides the Wyoming Office of Homeland Security may receive that criminal information, intelligence, and criminal enforcement information available to law enforcement agencies for the purposes provided by Wyoming Statute 1913-103. The second element allows the Wyoming Office of Homeland Security to receive the requested information for the purposes provided by that statute. To follow through on that, Title 19, Chapter 13, Article 1 is the Wyoming Homeland Security Act, and it provides that the Wyoming Office of Homeland Security be allowed, this is the second section there, be allowed but not forced to cooperate with other agencies in the state and with other offices of Homeland Security and with the Federal Department of Homeland Security. So to summarize, those two elements give DCI the ability to share the necessary information with our Wyoming homeland, and it gives the Wyoming Office of Homeland Security the ability to receive the information. So you got a pitcher and a catcher. And then finally, there was the big part of the concern I mentioned earlier on page 2, line 18, and that this bill will strike the word shall and insert the word may. This continues to allow the Wyoming Office of Homeland Security to liaison with and cooperate with other state homeland agencies and also with the federal government, but it leaves that decision to cooperate to the Director of the Wyoming Office of Homeland Security. This is consistent with other statutes that state that the governor may, but is not forced by state law, to coordinate with those other agencies as well. And that's spelled out in 1913-104B, where it says, in performing his duties under this act, the governor may cooperate with the federal government, with other states, and with private agencies in all matters pertaining to disaster relief and homeland security of this state and of the nation. So element 3 of this bill relieves our state offices from an existing state statute that creates a burden on our agencies to be subject to the federal government, and rightly puts those decisions in the hands of our governor and director. I've consulted the director of the Wyoming Office of Homeland Security, Director Budd, on this bill, and she has in turn consulted with the director of DCI, and they are in agreement that this bill will accomplish their desired goals. And with that, I'll stand for questions.
Thank you, Representative. Questions? Representative Chestic.
Thank you, Mr. Chairman. So is the only difference between this bill and the one that failed, is that the shall to may? Is that the only difference?
Representative Bratton.
Mr. Chairman, Representative Chestic, that is correct. I added the former House Bill 50, so that the offices can communicate with each other, and I just changed the shall to may.
So House Bill 50 did not contain that section of statute, right? That was not in 50 because it's existing statute, but it still caused
Yes.
concern, right?
Yes, it was a separate bill, which is why when I was asked if I could amend that on the floor, I was unable to, because it was not, that statute was not a part of the bill. So I added that, re-engross isn't the right word, but I recreated to make sure that they were able to communicate with each other, and then just added that to this bill.
Further questions? Seeing none? Ms. Chambers, are you wishing to chime in on this one? No? No way? Anybody else in the room on 329? Anybody on Zoom for 329? I'll close public comment in committee. What's your pleasure? Second. Moved by Lean, second by Filer. Discussion on the bill, amendments? Seeing none, please call the roll on 329.
Representative Brady,
Aye.
Representative Breton,
Aye.
Representative Chestic,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washet.
Aye.
9 ayes.
So Representative Bratton, you'll carry that on the floor.
Yes, sir, thank you.
Very good. You can take your seat up here. House Bill 102. Representative Heiner. Welcome, Mr. Majority Floor Leader. We love having nice thick bills early in the morning.
Thank you, Mr. Chairman and committee. It's a pleasure to be here.
So tell us what you'd like us to know about House Bill 102.
Thank you, Mr. Chairman. My name is Scott Heiner. I'm representing House District 18, and it's my pleasure to bring you House Bill 102, which is Attorney General elected. Members, we are often referred to as the People's Chamber. Each and every one of us are representatives of what is called the People's Chamber. And why are we called the People's Chamber versus the other chamber? I think it's because we are closer to the people because of our elections. Every 2 years, we spend time out walking the streets, visiting with people in our district, talking to them on their doorstep, going to town halls, walking in parades, doing all those things that we get to be close to the people. That's an opportunity and also something that puts a little bit more burden on us. What have you done this past summer? Most of you spent walking streets and visiting with people. But the side benefit to that is we're closer to the people. We hear what they want. We hear what they need. So the people's attorney should be the Attorney General. But how do we make sure that the people's attorney represents truly the people? We have an appointed attorney. There are, in the United States, 43 attorneys general are elected. There are only 5 that are appointed, and those 5 states that are appointed are Alaska, Hawaii, New Hampshire, New Jersey, and Wyoming. So not very many. Now 5 plus 43 doesn't add up to 50. Maine has an attorney general that's appointed by the state legislature, and Tennessee has one that is appointed by the Supreme Court of the state of Tennessee. So over the past number of years, Wyoming has been conspicuously absent from a lot of these lawsuits that are being put forth by Republican states. The lawsuits on that we've seen about immigration, healthcare, opioid epidemic, antitrust laws, environmental protection. How many times have you looked at all these states that are suing in behalf of their people in their state, and Wyoming is conspicuously absent? If you remember a few years ago, when we were trying to get an export terminal for coal, we didn't use the Interstate Commerce Clause. We didn't sue for that until it was too late. And we lacked standing because the company went bankrupt, because we delayed and didn't really get on board with that and helping to get access to the West Coast. So before I go to the bill, just one other side note. Will this create a stepping stone for more lawyers, more attorneys to become governor? That's another question that may come up. Of all of the governors in the United States, there are only 16 that have a Juris Doctor degree. So that it may or may not, but by that number, it doesn't lend to be something that is actually a stepping stone. So going into the bill, Mr. Chairman, I know you're pressed for time, you have a lot to do today. But going into the bill, I'll just walk you quickly through it. It's pretty thick, but a lot of it is just conforming amendments.
This is an important topic, Mr. Majority Floor, so we'd like to err on the side of quality rather than quantity this morning.
All right, so page number 2, line 12, it says it will commence following the 2026 general election. The Attorney General of the state of Wyoming shall be appointed up until that time. So the first election would be during the general election of 2026, and then it will be a 4-year term thereafter. You go to page 3, because we would then have 6 elected instead of 5. On page 3, we're talking about the State Building Commission. On line 18, it goes from 5 elected state officials, governor, secretary of state, state auditor, and state treasurer, and the state superintendent. They will still be the State Building Commission. So the Attorney General will not be added to that State Building Commission, but rather than just saying the 5 elected, we had to enumerate who those are. Then carrying on, some conforming amendments, but you get to page 7. Now we got to deal with some of these actions that have been directed by the governor in the past. As this becomes an elected position, we have to strike that the Attorney General or County Attorney shall commence an action when directed by the governor. We strike that. And on lines 8 through 12, we say that the Attorney General may commence an action when requested by the governor, the Supreme Court, or the legislature. So that Attorney General would represent all of us. And again, the county attorney shall commence an action when directed by the governor, Supreme Court, or legislature. Page 8, you'll see some conforming amendments. before, line 9, we strike subject to the governor's approval. And line 10, it says the Attorney General may employ specially qualified assistants of counsel. So give some autonomy to the Attorney General's office to work and act in behalf of the people. So you'll see a lot of that. Page 9, we strike 5 state elected and replace that with 6 state elected and add Attorney General to that list. And you'll see on page 10 and 11 conforming, just going from 5 to 6. Jump to page 14, vacancy in office of the governor. This is going to be a question. How does the vacancies work with an Attorney General? So on line 13, that's where statute 9-1-211, where it deals with the vacancy of office of the governor. And on page 15, the Attorney General falls not at the top. It falls just above the state superintendent of public instruction. So the Secretary of State, Treasurer, and Auditor would stay in their positions that they are in right now as far as the order of replacement. Further down on that page, on page 15, a vacancy in the office of the Attorney General will be replaced as with other elected, of our 5 elected, right, our 4 elected. So it will be appointed based on recommendations. We just recently had that happen with the Secretary of State when our Secretary of State resigned and the governor was able to appoint, based on 3 recommendations that he got, he appointed temporary Secretary of State until the next following election. So this would follow that same format with our Attorney General. So the next few pages, again, are conforming amendments. There's so many statutes that talk about the Attorney General and the things that the Attorney General will do based upon being directed by the governor, and we have to change all of those in all the different statutes. But page 23, it sets the salary of the Attorney General at $175,000. And finally, I'll go to the very last page, the enacting. Section 3 on page 34, you'll see that there's 2 separate times for enacting. Section 2 will enact on January 4th, 2027, and that's the duties changing after the election and when the new Attorney General becomes sworn in office. So Section 2 commences on page 5, so all these duties change at the time the Attorney General is sworn in. So up until that time, the appointed Attorney General will still be answering to the governor. So members of the committee, I'm open to questions and stand for any questions you may have concerning this bill. I appreciate your time, Mr. Chairman.
Thank you for the presentation. Committee Representative Shusting.
Thank you, Mr. Chairman. Majority Leader Heiner, thank you for bringing this to us. It's an interesting topic. I'm not sure how I'm going to vote on this. I have some questions about it. I just wanted to start off by saying I did not really appreciate the implication that having a JD as a lawyer is a bad thing. That's what this implication was, I thought. But be that as it may, one thing you can ask people any question you want at the door and find out what their thoughts are. If I were to ask a question at the door, do you want more politics in state government or less? I'm not sure we'd say, yeah, I want more politics. And that's what this bill does. It creates a 6th political office, and seems to me that it creates some conflict. And maybe conflict is good. Sometimes conflict is good. Conflict is useful, but sometimes it's not. Having an independent Attorney General who may be at odds with the governor. So the litigation, the statewide litigation that you're suggesting that we're not part of, maybe that's because we shouldn't be part of. Whoa, I don't know what's going on there. If the governor says we shouldn't be involved in this lawsuit and the Attorney General says we are, we join the lawsuit and everybody says Wyoming has joined. Well, Wyoming is represented by a lot of people, including the governor. And the governor says no, and the attorney general says yes. We're creating a mixed message, I think, where we have two elected people who disagree with each other. How do we resolve, who represents Wyoming in that situation? I have a problem with creating these kinds of conflict, and it's going to happen. We know it's going to happen. What's your reaction to that?
Representative Heiner.
Mr. Chairman, Representative Chesnick, thank you for that question. And I, by no means was disparaging Juris Doctors. Some of my family are Juris Doctors, and I love them very much. I'm only 8 years away from additional schooling to be a Juris Doctor, but I'll probably never make it. But I appreciate the question. Our forefathers set up the 3 branches of government for the very reason that you mentioned, to purposely create that differences of opinion so we have checks and balances. By having that difference of opinion here in the state with our elected, that is a good thing. It provides that check and balance. So we don't have one person directing the Attorney General. It becomes a consensus by group, by the elected, by the people, more or less. The Attorney General responds to what that person would feel is best for the people of the state of Wyoming. Now, on page 7, it talks about the Attorney General may commence an action when requested by the governor, the Supreme Court, or the legislature. Those are the 3 branches of government. So the Attorney General that would then be more open to suggestions from the other branches of government. And we've seen legislation come through over the past couple of years, Representative Chesnick, about giving the legislature more money so that we can pursue legal actions on our own, because we're not getting that response that we think that we need as a branch of the government. So with this bill, it would provide an avenue for all 3 branches to be equally represented by the Attorney General, rather than just one branch.
Representative Kelly.
Thank you, Mr. Chairman. The good lawyer had some of the same points I was going to make, but I wanted to build on that. This would make the Attorney General's office a much more political elected spot. What is there to guard against the Attorney General becoming an office that, rather than pursuing the best legal interest of the state, pursues the best prospects for election or re-election? What are the safeguards from turning this AG from Attorney General into aspiring governor?
Mr. Majority Floor Leader.
Thank you, Mr. Chairman. Mr. Chairman, Representative Kelly, this is a bill that I've been working on for 4 years. And this is the first year it's had a chance to be heard, but I held it back for those very reasons. I was worried about it being a position that could be bought during the election. I was very concerned about that. I don't want it to be something that becomes bought with money. And I drafted another bill that would make this position still appointed, but appointed by the SLIB rather than just the governor. The other chamber was not open to that idea. But ultimately, the decision to bring this forward was based on trusting the voters, trusting our citizens to make the right decision. So if during an election there's a lot of money coming in, we need to be transparent with where that money's coming from and trust the voters to make the right decision. It happens with the other elected. There's a lot of money in those 5 positions for our state. We have, as voters, we have to realize where that money is coming from and make choices based on who is supporting those candidates. We choose the best candidates, and ultimately, my decision to bring this forward was the trust of the voters to do the right thing. And that's why it was brought up at the late hour. You know, we're almost to the end of our crossover here. But that was a difficult decision for me.
Representative Filer.
Thank you, Mr. Chairman. Representative Heiner, I'm just trying to think if, outside the box here, and I'm looking outside in right now. Right now, as a citizen of the state of Wyoming, there's processes and ways that we can actually go to our Attorney General with some issues. And they do at this time have to pretty much represent us and, you know, with the direction of the governor also. If we make this an elected position and there's no checks and balances as far as if they are doing their job or not, we're stuck until the next election. If we want to take issues to the governor or to the attorney general right now and they just push a issue to the side, and they're not doing their job correctly, there is processes in order for the governor to ask for resignation, reappoint, to put somebody in that position that's going to do their job. If we elect it, we're stuck till the next election. And I understand what you're saying by hopefully the voters do the best they can when they're hiring somebody at the ballot box. But would this cause maybe an issue when it comes to just the average citizen asking their hired attorney general to do their job instead of an elected attorney general to do their job?
Mr. Majority Floor Leader.
Thank you, Mr. Chairman. Representative Filer, thank you for that question. This will be no different than our other elected officials. If our Secretary of State or our Treasurer fails to do the job, it'll be the same avenue, the recourse to replace or change that. But I go back to page 7 where the Attorney General upon requesting by the Governor, Supreme Court, or Legislature, the Attorney General may commence action. So it won't be an autonomous position that is siloed, with no input from anywhere else. That Attorney General will work for the 3 branches of government rather than just one branch of government. So I think it'll expand those responsibilities and actually enhance the being able to get being able to truly represent the needs of the state rather than just one branch of government. So I think it'll benefit us.
Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today, Majority Floor Leader. My question is about the employees within the AG's office. Do those remain full-time employees or at-will employees with that change?
Mr. Majority Floor Leader.
Mr. Chairman, Representative Lean, I do not see any changes for that based on this. It's just instead of an appointed person as Attorney General, it'll be an elected, but the staff will be at the pleasure of the Attorney General.
Representative Shestak.
Thank you, Mr. Chairman. Majority Leader, I want to get into the weeds a little bit on one of the pages. On page 7, I do appreciate very much the change of shall to may for the Attorney General. If the Attorney General is requested to commence an action, the may, I appreciate that very much. It allows the attorney to exercise professional judgment as to whether it's a legitimate lawsuit or not. So I like that. But line 10 through 12 gives me a lot of heartburn, to be honest. So you say the Attorney General may commence an action when requested, but then a county attorney shall commence an action when directed by the governor. That looks to me like you're able to shop for your attorney. So if the Attorney General exercises professional judgment and says, I'm not going to file this suit because it's not a good, it's not authorized by the law, or it's not a good lawsuit for whatever reason, you can go pick any county attorney who is not elected by the whole state, only elected by one county, and say, you shall do it. So is that a cudgel to use against the Attorney General? And does the county attorney who shall commence it has no, is required to take away from other responsibilities they have to the county and do this instead of what they ordinarily would be doing? I have a lot of heartburn with Who was the client when the county attorney shall commence? Who was the client? Is it the legislature? Is it whoever asked them the client? Is it the state of Wyoming the client, even though they're not elected by the state? A lot of problems with that. Could you explain to me what the purpose of that line 10 through 12 is?
Mr. Majority Floor Leader.
Thank you, Mr. Chairman, Representative Chesnick. The process of bringing a bill forward this is the first process is going through a committee, hearing public testimony, working as a group to fix and improve upon bills. As I worked with the LSO and outside attorneys from different groups, this was a comment and discussion we had about that particular point that Representative Chesnick brought up. With this bill, we're trying to focus on the Attorney General and not change anything surrounding that. So right now, the way the statute is, county attorney shall commence an action when directed by the governor, Supreme Court, or legislature. So we're leaving that as it is right now. We're not changing anything with the process of county attorneys because we wanted to focus on the Attorney General and not get down into the weeds, as you mentioned, with a county attorney. So the committee may decide to change that, but our intent was just to focus on the Attorney General and not change anything with the counties.
So this language, Mr. Majority Floor Leader, is in existing statute. Is that your testimony?
Yes, Mr. Chairman, thank you.
Yeah, it shows up as new because it's new in that section, but apparently it exists someplace else in statute.
Mr. Chairman.
Yeah, Mr. Vice Chairman.
Thank you, Mr. Chairman, Majority Floor Leader, good morning. My question for you, it has to do with page 15 on the order of succession. Can you talk to us a little bit on how you ended up on putting this newly created position of the Attorney General, elected Attorney General, before the existing position of the State Superintendent? It'd be my understanding that if the State Superintendent had already won an election, that there would be more familiarity with the necessities of the executive branch, and therefore having a new person in the Attorney General's office take the helm of governor before the superintendent would be counterintuitive. And then also, does this, by inserting another position in the executive branch before members of the legislative branch, does that disenfranchise the legislative branch?
Mr. Majority Floor Leader.
Mr. Chairman, thank you. Representative Singh, that's a very good question. This statute is intended not only for the short term, but for the long term. So you're exactly correct. With an elected Attorney General, when this first happens in 2026, that Attorney General may not have a lot of experience in the executive branch. But 10 years from now, it may be very different. So that was the thought process, is the qualifications and what other states do with their line of succession. So that's why we came up. We tried to look at that and what other states do, and that's why we pointed in there at that point. Now, is that the right spot? It's not something I'll fall on the sword for. It's something that can be moved around however this committee would like to recommend. But yeah, is that, as a member of the legislature, is it our desire to be further up that chain? Personally, not mine. That's not my goal, is to ever be in that succession line of the governor. That's I'm happy with being way down on the food chain.
Representative Ling.
Thank you, Mr. Chairman. Mr. Majority Floor Leader, I'm curious about the wages. It says no fiscal impact on the back under the statement. How did we come to $175,000? Is that the current salary?
Mr. Majority Floor Leader.
Mr. Chairman, thank you. Representative Lean, yes, that is current salary.
So, Mr. Majority Floor Leader, I think about when the 5 elected get together now for various roles to consider things. The Attorney General's I would think serves as a bit of a resource for all of the 5 elected officials as they debate different things. But if you have an elected attorney general, then the attorney general is part of the decision-making cadre as opposed to a legal resource for the group. So I think about a city council, where you've got the elected on the dais, and you've got the city attorney sitting over there in reserve, ready to chime in and help with legal questions that might arise during the debate. When you then put your city attorney as one of the elected city council members, all those dynamics change, right? Now they're part of the deliberative process rather than the advisory process. So that's my philosophical concern here. Could you dive into that one for me?
Thank you, Mr. Chairman. And as an example, I'll give you an example of your committee right here. You have some juris doctors on the committee that also are able to weigh in with their testimony. So I think it strengthens your testimony, your committee, to have that experience that you can draw upon, and also have that they're able to provide testimony and weigh in on the ultimate decision. So I think in the legislature, it makes us stronger by having members of the lawyers actually part of our decision-making process. So if I may, Mr. Chairman, the other question that may be wondering about from the committee is if with 5 elected, there's always a clear majority. You have 6 elected, then what happens? Well, in our committee, our interim committees, a lot of those are set up that way. We'll have 14 or 12, and a split vote is a failure. It has to be a clear majority. So if there's 6 elected and it splits 3-3, that fails. So that is something we can work with as well.
Mr. Vice Chairman.
Thank you, Mr. Chairman. Majority Floor Leader Heiner. So for some of the elected offices in the state, such as the county commissioners, for example, there's an additional requirement that they own property in order to take up that position. Are there any additional requirements other than winning the election that would be required for this office of Attorney General?
Mr. Majority Floor Leader.
Thank you, Mr. Chairman. Representative Singh, page 3, lines 8 through 13. It says, to be eligible for appointment or election, the Attorney General shall have been a practicing attorney for at least 4 years, shall be in good standing in the courts of record of this state, and shall be a resident and elector of the state.
Further questions? Representative Bratton.
Thank you, Mr. Chairman. And how much of a change is that from the prior qualifications?
Mr. Majority Floor Leader.
Thank you, Mr. Chairman. Representative Bratton. So if you go to page 3, you see the strikeout. The strikeout is prior to his appointment, and we struck that and said to be eligible for appointment or election. And so that's, the short answer is no change.
Representative Cheswick.
Thank you, Mr. Chairman. So kind of following up on the chairman's questions from a moment ago, I'm going to draw on my own prior experience when I was, an age ago, when I was a practicing lawyer in a different state. I represented a county. I was a county attorney for a number of years, many years. And I viewed my client was the county, but the county had different branches. It had a county council, it had a executive, it had a planning office, it had district, it had a lot of other offices, similar to what the state has right now. We have the Attorney General right now kind of represents the state and can give advice to all those different branches of the government, of the executive branch. He's the executive branch lawyer. She is the executive branch lawyer. So there's a lot of conflicts that show up, and those are difficult for any attorney to navigate. I learned how to do it, but it's sometimes difficult. But sometimes you need independent counsel for these people. If we take the Attorney General out of the governor's appointment process and give them an independent base of power by electing them, who serves the role of counsel to the other branches of government? It's not common for the attorney to have separate power above that of the client. So when I was representing my county government, the client was whoever the officer was that needed advice, they were the client, and I gave them advice. I didn't have any independent authority over them. If I'm an elected official, I do. And so I then am in charge of the situation because I don't have to do what they tell me to do. I have an independent base of power. That's a problem to me. But the more specific question that I have is, if you take this office and make it elected, are you going to replace that person or give the governor his own counsel? Create an office of the governor, a counsel to the governor to serve, because the governor is sometimes going to need to have a lawyer that answers to, that advocates for the governor. If the lawyer disagrees, if the attorney general is elected and disagrees with the governor, they're not going to represent the governor very well. The governor still needs representation. So how are we going to give the governor the representation that they need and be the client with a lawyer that serves him and not the attorney's own interests?
Mr. Majority Floor Leader.
Mr. Chairman, Representative Chesnick, that was a question I had when I was working with a lot of outside attorneys and firms. What would stop the governor from hiring his own counsel? I apologize, I got a lengthy description and explanation, but I did not bring it with me. So I would be willing to forward that to you after at the committee, but they gave me quite a write-up how that probably would not happen, and I would share that with the committee.
Follow up?
Then maybe it should happen. Maybe the governor does need separate representation at times. Shouldn't we allow that to happen? And this seems to create a potential barricade or blockade to allowing what could be a good thing from happening.
Don't think that was a question, but would you like to respond to it?
I'm trying to, no, I won't respond to that.
Representative Lean.
Thank you, Mr. Chairman. In the process of building this, did you give any thought to a term limits for this position?
Mr. Majority Floor Leader.
Chairman Washut, Representative Lean, that had been tried before and the Supreme Court struck that down for term limits for four elected, except for the governor. That has not been struck down. So the answer is no.
Further questions? Okay, do you have any witnesses in the room that you'd like us to hear from, or is it just free for all from this point?
My friends are right here in front of me.
All right. We'll just wait. I see you. All right, thank you, Mr. Majority Floor Leader.
Thank you, committee and chairman.
Okay. Others in the room wishing to testify on House Bill 102, please come up. Good morning. Please introduce yourself to the people watching on YouTube while they're eating their Cheerios, and tell us what you want us to hear.
And still in their bunny slippers. Good morning, Chairman and committee. I'm Gail Simmons from Sheridan. I am with Civics 307 and Why Vote. So I have a few points to make about an elected Attorney General. First is, as was pointed out, the Attorney General's role is to provide impartial legal advice to the state government, all of the executive branch of the state government, and in fact, to the legislature when requested in particular instances. Making it an elected position could introduce political bias, undermining the objectivity needed for sound legal advice. It also causes that office to focus on law, or it should focus on law, not politics. An appointed AG focuses on legal expertise, not campaign promises or political agendas, ensuring decisions are based on law, not electoral processes. So, Mr. Chairman, the next one, again, touched on some of these. It has a streamlined executive function where the current system ensures that the AG works directly with the governor, promoting cohesive policy implementation and legal consistency across all state agencies. Also, with an appointed AG, the governor is directly accountable for the AG's performance. An elected AG could provide divided accountability, making it unclear who's responsible when issues arise. It also avoids increased costs and bureaucracy. Introducing a statewide election for the AG adds unnecessary cost to taxpayers, including expenses for campaigns, ballots, and administrative oversight. Note that I'm assuming that the taxpayers are the primary source of campaign funds, which is probably a pretty bold assumption given current election finance. Also, preserving legal professionalism over popularity contests. It ensures that the AG is selected based on legal qualifications, not campaign charisma or political alliances. There's also the risk of politicization. States with elected AGs often see candidates campaigning on hot-button issues, which we've seen several times here in this legislature, where we're talking about national issues rather than state issues, and this introduces that at the Attorney General level as well. So it erodes the AG's role as an impartial legal officer focused on the rule of law. I would also state, Mr. Chairman, that there are some lessons to be learned from other states. Many states with appointed AGs report more stable, less politicized legal environment. Where AGs are elected, conflicts with governors can lead to legal gridlock, undermining effective governance. And in fact, that already exists within the top 5 elected, where we see that showing up in things like the SLIB board. Wyoming's current model promotes consistent legal strategies across administrations. Elected AGs may shift priorities dramatically with each election cycle, causing legal uncertainty for state agencies and and citizens. And finally, we have unique needs as a small state. Wyoming government operates efficiently due to close-knit relationships and streamlined processes. Introducing statewide AG elections could disrupt this dynamic and create unnecessary political divisions. And finally, in that area, if it's not broken, Wyoming has not faced systemic issues with the current AG appointment process. This change addresses no urgent problem, potentially creating new complications without clear benefits. It appears that a lot of the concerns about having an elected AG actually stem from concerns that 6 years ago, a governor was elected who does not enjoy the unquestioning support of a political party, but that rather of the citizens. In states that have an elected attorney general, the standing joke is that AG stands for aspiring governor. Let's not make that a reality in Wyoming, and I stand for questions.
Thank you, Ms. Simmons. Questions? So I do have one. You've obviously taken some time to look at these other states that have elected attorney generals. Is there a positive side? Any upside? You pointed out the negatives pretty well. Have you seen any positive benefits of having an elected AG?
Mr. Chairman, I actually do not. And a lot of that is due to, this is, the old Rube rubric or whatever it's called about this being a small county with or a city with long streets. This is a community. This state is a community. We actually, with only 500 and some thousand residents, we know the people in our communities. And when that community extends to the state, we know the state as well. I just honestly do not see any upside to an elected attorney general.
Thank you. Representative Vice Chairman.
Thank you, Mr. Chairman, and Ms. Simmons for being here this morning. You had talked about the tight-knit nature of having elected officials, and here in the legislature, we definitely experienced that with our rapid elections and having to be accountable to the people. I guess you're sharing that there isn't really an upside to having the electorate make this complicated decision. Do you think they're not capable of making an informed, intelligent decision when it comes to an elected AG?
Ms. Simmons.
Mr. Chairman, Representative Singh, I will correct you and say I said neither of those things. I look at what the current primary qualification is for the AG, and as pointed out, it has to do with legal expertise. When you turn this into an elected office, legal expertise becomes the least that consideration I think that most people would have. It will become about politics and some of the other things that I stated. The current AG, through the governor, represents the people and does it very well. I would like to point out, Mr. Chairman, that the U.S. Attorney General is an appointment. If you're really concerned about that, then having the appointment be subject to, which I believe it is, subject to the approval of the Wyoming Senate, then we've exactly mimicked what we have in at the federal level.
Ms. Simmons, when you've looked at these other states, is it common then that the other elected officials then have their own on-staff legal staff, so that there's a counsel to the Secretary of State and a counsel to the governor and a counsel to the superintendent, and so that these other states, do they have their own lawyers to advise them?
Mr. Chairman, I don't know, but I would not be surprised. And in fact, whether they are there officially or they get their personal counsel, I'm sure that could be possible. And again, I look to Wyoming, and as I said, I didn't look at that level. That hadn't occurred to me, actually, until it was brought up previously in this meeting. But we don't need to have all branches of all departments within our executive branch have separate legal counsel. And I suppose it could be that the elected Attorney General could appoint somebody from his staff to have that be a part of their duties, is to also represent a department within the executive branch.
But would they feel that appointed counsel coming from their peer on the 6 elected is impartial and giving them the best counsel, or are they giving the counsel that the elected Attorney General wants that office to receive?
Mr. Chairman, I expect it depends on the personal dynamics of the elected offices. I would like to think in Wyoming that they would feel like the Attorney General would be a team player and not make sure their staff does not undermine them. But we're talking about human beings and human ambitions.
Thank you. Further questions? Mr. Vice Chairman.
Thank you, Mr. Chairman, and again, thank you, Ms. Simmons. I guess my concern by not having this be an elected position that the voters of Wyoming, especially so many voters that feel disenfranchised by a party system, that because we're defaulting this important position to an executive that many folks in the state just simply disagree with, that by not having this be an elected position, that we would disenfranchise those voices who would otherwise have an opinion on how this particular position would operate. What do you think about that?
Mr. Chairman, Representative Singh, I believe, trying to do quick math in my head, that for 135 years, we have not had an issue, since becoming a state with the Attorney General being appointed. I don't see anything that has changed that. And I have not seen anything except within political party structure that has indicated otherwise.
Very good. No further questions. Thank you for being
Thank
here
you.
this morning. Now you can go have your Cheerios. Welcome, sir. Please state your name for the record. Make sure your little green light comes on your microphone. Speak into the microphone. Make all your comments through the chair. Don't engage directly with any member on the dais. Please tell us what you want to know.
My name is Philip Rujeski. I'm a professional engineer here in the state. I own an engineering firm and a construction company within the state. And I live here with my family. I'm also active in the Republican Party, but I'm coming to you as a private citizen. I'm very much against having the Attorney General be an elected position. And so I want to talk about the principles or the workings of an election. And first of all, you'll notice that many of the other states that have elected attorney generals are bought by very wealthy people, George Soros being one of them, but not just him. And so what would happen in our state if we were to have an elected position is that we would have the two positions that are involved here is the governor and the attorney general. The people of this state really pay close attention to the governor's race, but not necessarily to the race of an attorney general. And so what's happened then is if the Attorney General were to go through the campaigning process, that campaigning process would be, the money provided for that campaign would be from people or organizations that felt like they could have control of that, of the Attorney General, and would have a lot of money to put into that race and would have some control. And then the other thing is that an attorney general that was given money to be able to win a race like that, those same people that gave them that money, then when it came time to elect a governor, would push that attorney general to run for that position, and the attorney general would have name recognition and would have money behind them and would be able to run for that position. Now let's talk about the people that give money for attorney general races in the United States, and I think we would see that here in this state, is large law firms, and law firms that aren't just local here, but that are national or international firms. That's where that money comes from. Often it comes through those firms from bad sources. There's the George Soros thing, but even the firms, and those large firms themselves, are generally liberal. They're generally big government, and are less concerned about our freedoms and more concerned about the control that they have in the government. So if we were to have an elected attorney general, I'm afraid, and a lot of other folks are afraid, that we're gonna end up getting attorney generals that are very liberal. And by the way, you see that in a lot of other states. And we're gonna see then that we have a good candidate that has some money and the name recognition, that is liberal, working towards becoming the governor. So in the appointed position that we have now, what we need to do is get a good governor that understands our freedoms and how important it is for the people to be truly represented in the state. So a lot of people pay attention to that race, and you have less influence in the big money people than the people themselves in our state. And so it's better than, and if you get the people in the state of Wyoming to vote for a governor, you're often going to get a conservative governor and a governor that understands our freedoms. So it's better for us to have one elected position, which would be the governor, that people pay attention to, and then have that elected position appoint an attorney general. So if we can get a conservative in the governor, we're going to have a conservative attorney general. So I'm very much against the election of attorney general, and that's my reasons for that.
Thank you for being here, Mr. Lejeski. Committee, any questions?
Thank you.
You did.
Oh, go ahead.
You did spawn a thought in my murky early morning brain, that if these law firms contribute to a campaign by an attorney general, are those law firms then more likely to be selected when outside legal talent are hired to represent the state in some type of litigation?
Yeah, I think that the large law firms, I'm not talking about the local firms here, but the large law firms tend to be really for bigger government because it gives them and their clients more power. And so those law firms and other very wealthy people want to have control over or some real influence on the attorney general, but they also want to have influence of getting a liberal attorney general in there who eventually can run and win the governor's race.
Thank you for being here this morning. Appreciate it.
Thank you.
Good morning.
Good morning, Mr. Chairman.
Nice to have you here.
Thank you. Good morning, Mr. Chairman, members of the committee. Green is on. My name is Betsy Anderson, and I am Governor Gordon's Deputy Chief of Staff and General Counsel. I'll try to be fairly brief with my comments because I think a lot has been covered by your questions and Ms. Simmons' testimony, but I did think you might want the perspective from our office. So with regards to this bill, the governor believes that our current system of appointing the attorney general serves the state much better than a system where the attorney general is elected. First issue, as you've discussed a lot here, is independence. An appointed AG is more independent and can focus their attention on the law and legal concerns instead of political concerns. Elected AGs are more exposed to political influence in decision-making, and they can become beholden to those who support their campaigns, which you've already discussed. The question becomes, how can an elected AG be independent when they have accepted contributions from individuals and entities for their campaign? Independence and an absence of conflict are essential when considering the ethics of an attorney. An elected AG flies in the face of an independent AG, but an appointed AG is a step removed from politics and can focus more on what is best for the state without undue influence. More specifically, an elected AG may be called on to bring action against those who have been campaign contributors, which presents a very difficult ethical consideration for that person. In addition, the time spent campaigning distracts from the duties and responsibilities of the office. And finally, good campaigners are not necessarily good attorneys. Some are not. Another concern is animosity and inefficiency. An elected AG and governor may have differing policies and priorities, which would frustrate the goals of the governor. And I know maybe that's the goal of this bill, but it is the governor who is the duly elected official to lead the executive branch. An elected AG may disagree with policy choices of a state agency, leading to disagreement and inefficiency. In states with an elected AG, oftentimes state agencies hire their own in-house counsel, which grows state government. And it is quite common for an elected AG to aspire to the governor's office, which you've talked about. This creates a situation where an elected AG is perpetually running for the governor's office to garner votes and prevents them from making objective legal decisions. And I know Majority Floor Leader Heiner did bring up that only 16 governors have JDs, but that doesn't mean those AGs aren't running for that office. As Ms. Simmons made a reference to, it is the National Association of Attorney Generals, the NAAG. As an attorney, I like to say fondly called NAG, but it is oftentimes referred to as the National Association of Aspiring Governors. So then that leads to the issue of costs. Because of this animosity, an elected AG means that the governor must have a larger legal staff, as he cannot rely on the elected AG to support his legal needs. And you have brought that up. The governor's office currently has 2 attorneys. Me as general counsel, but I play a dual role as deputy chief of staff. So I really only oversee legal matters at a high level. I have a special counsel who reports to me, and he does the heavy lifting, does an excellent job, a lot of the rule review, public records requests, just a lot of stuff that unfortunately is kind of some of the mundane work of the government, but he's signing those public record, signing those rules, consideration of pardons and clemencies. There's a lot of day-to-day work. We rely on the AG's office heavily. There's no way with just 2 of us, and I think you would have to have a considerably larger staff for the governor if you have an elected AG. Also, disagreements with state agencies, as I mentioned before, mean that in many states with elected AGs, each agency hires its own legal staff. Chairman Washit, you mentioned how the other electeds do by statute, except for the superintendent, have the ability to hire their own attorney. I am the product of that. Treasurer Lummis in 2004 got the law passed so that they could each have their own representation, and I was hired at that point in time. That is just, they are elected in their own right? And it was difficult. There was appointed AG, but you can imagine as an elected AG, that elected AG no longer represents the executive branch as a whole. So each of those agencies, if they feel like they're not getting the legal advice they need, then they're going to be hiring their own attorneys. I will also suspect that elected AGs have much larger staffs than those of appointed AGs. So this is going to result in the state hiring a much larger number of attorneys and greatly increase the cost of running state government. And finally, to an issue you've already discussed a little bit, it's much more difficult to remove an elected AG as they would most likely have to be impeached. With an appointed AG, the governor can remove the AG without cause. That is how it exists today. So if there's any unethical activity, if you feel like the attorney general is not being responsive for any basis, the governor can immediately terminate that person without cause. So these are the main reasons why the governor does not support the bill. And we hope that the legislature recognizes the benefits and advantages of having an appointed AG. And I'm happy to answer for any questions you might have.
Ms. Anderson, thank you for being here. Representative Kelly.
Thank you, Mr. Chairman. Excuse me, I've got the same frog as the chairman. Okay, as has just been stated, that the appointed Attorney General serves the pleasure of the governor. And a problem with having an elected one is the introduction of politics into that arena. Others might argue that the introduction of politics means influence by the people rather than influence of one person. Serving at the pleasure of the governor, a criticism of the appointed AG is that this is not the state's attorney, this is the governor's attorney, that the AG is not independent, but will do whatever the governor wants or be fired. So first, if you could speak to that concern, I would appreciate it. I'd also like to say that if insulating these executive positions from politics is beneficial, why not have the governor also appoint the Secretary of State, the treasurer, and the superintendent to run the entire executive branch much more efficiently?
Ms. Anderson.
Mr. Chairman, Representative Kelly, with regards to the Attorney General, I do see, I mean, I think the people could elect that position, but but they also elect the governor, and they have elected the governor to represent them on a statewide basis. And so to have an elected AG can very much thwart what the governor's policies are. So now you have these conflicting policies. So I feel like they have spoken, and they've spoken by electing the governor. With regards to the other, and so I feel like the role of the Attorney General is not a policy person. It's a legal, they are providing legal advice. They need to be objective, unbiased, impartial, and at this point, there's no way, policy always plays a role. There's no, I get that. They need to be as impartial as they can. But we've elected the governor, and that's who the people have decided those are the policies they want to go by. And have somebody always trying to, who might make that difficult, I don't think is helpful. And then as to the other positions, I do think those have policy roles. I mean, superintendent runs education, and there are a lot of policy issues involved with that. And I think the people of Wyoming, their thoughts and beliefs on their education for their kids, they should have a say in that. So I do see those roles, how elections are conducted. I see the people playing a role in who they want to make those decisions. So I see just the role of those positions is different, and that's why you would elect the ones we elect now, but why you would not want to elect the Attorney General.
Other questions? Thank you for being here this morning.
Thank you.
Anyone else in the room wishing to speak on House Bill 102? Anybody on Zoom? Please bring them in.
Good morning, Chairman and Committee.
Good morning. State your name for us and then tell us what you want us to know.
Hello, I am Jenny DeSaro. I am with the Equality State Policy Center. And we are a nonpartisan organization started by Wyomingites in service of Wyomingites, committed to ensuring fair elections and transparent government in Wyoming for over 30 years. The Equality State Policy Center, this is a step toward increasing partisanship, which we oppose. In fact, our president of the United States, our first president of the United States, George Washington, in his farewell 1796 address, warned against the baneful effect of partisanship and called upon the people to take a more comprehensive view. Growing up on a ranch in Wyoming, I was taught the value of critical and independent thinking, not to be a follower, unless we were on the trail in a pack string. Although other states may do this, it is not the correct path forward for Wyoming. The Attorney General provides impartial legal opinions only to the elected and appointed state officials and represents the state agencies in actions in courts of law. This position is most effective when they are able to maintain an independent mind free from the confines of partisan platforms. It enables them to rise above the divisive political discourse and focus on the laws as written, supporting the state agencies and officials from a neutral and skillful mind. Our current way is the best way. It isn't broken. In fact, it works for Wyoming to have a nonpartisan appointed AG. We encourage you to oppose this bill. I stand for questions.
Thank you for being with her this morning and offering that testimony. Any questions, committee? Thank you. Is there anybody else on Zoom? And no one else in the room? And close public comment. Committee, what's your preference? Move the bill. Moved by Vice Chairman, second by Webb. All right, let's work the bill. Well, before we go, let's let the majority floor leader give us some concluding comments before we work the bill. You've heard a lot of testimony of other people with different perspectives. I'll give you one bite of the apple before we jump in.
Thank you, Mr. Chairman. I just would like to point out that many of our five electeds already have counsel of their own. We've seen it here today. I know some of the other electeds have their own counsel. They not only have counsel, they have staff that are attorneys. So will this change the mode of operation? I don't know. I don't think any of us can predict that. But even with an appointed attorney general, they are relying on staff that have other attorneys present. So I don't think it's going to change much in that respect. But that's about all that I have for comment, Mr. Chairman. Thank you for giving me that opportunity.
You're more than welcome. Thank you. All right, let's work the bill. Any amendments? So we'll take it page by page. Page one. Page one, any amendments? Proposed amendments? Page two. Seeing none. Page three. Page four. Page five. Page six. Page seven. Oh, Representative Chestic.
Thank you, Mr. Chairman. On page 7, as I suggested during my questioning earlier, I have a great deal of heartburn over the lines 10 through 12, the sentence, "The county attorney shall commence." I would propose an amendment to delete that sentence.
Is there a second? I'll second it for discussion purposes. How's that?
Thank you, Mr. Chairman. As I suggested in my questioning, I think this creates an opportunity for either the governor or the, what's the list, Supreme Court or the legislature, if they can't convince the Attorney General to file a lawsuit on their behalf, they can commandeer a county attorney from anywhere in the state to do that instead and require them, because it says shall commence. That creates issues for that county who loses the services of that county attorney for potentially political reasons. And it also is a way of undermining the authority of the Attorney General. It's kind of, if you don't do it, I'll find somebody else to do it. I have a great deal of problems with that. It also impairs the professional judgment of that county attorney. The county attorney says, I think this is a bad lawsuit, we're going to lose it, It's not justified by the law, but I must do it because it says shall commence. So you're undermining the professional judgment of whatever county attorney gets tapped to do this. So I think this may appear somewhere else in the statute books. I'm not sure where that is. I would assume if it is, it might be in a different context. But putting it here in this immediately following the sentence which says the Attorney General may commence, but if they don't, then the county attorney shall do it. The difference between may and shall in those two sentences is stark. And I think it's just a terrible idea, and I would support removing that sentence from the statute.
You know, I'm always fascinated in this role as you come upon these little nuggets of information that, you know, this is in statute, and you scratch your head and say, I had no idea. If you'd have asked me a week ago, can the Wyoming Supreme Court, the judicial branch, dictate to a county attorney that they'll commence a legal action? I said, no, there's no way that the judicial branch would have that authority. And then here we are, right? So, Representative Lean, did you have a comment?
Just a question for the bringer of the amendment. Versus striking out the whole thing, why would we not just change the shall on 10 to a may?
Representative Chesty.
Thank you, Mr. Chairman. That makes it a little better, but that still doesn't solve my problem because it still basically says if you can't find, if the Attorney General disagrees with you, you can still go shopping for another attorney who will do it. And it still undermines the authority of the Attorney General. Whether it's a may or a shall, you still have that secondary option to undermine the Attorney General, and I still don't like that either.
Further discussion on the amendment? Okay, does everybody understand the amendment? We're going to proposed amendment on line 10 through line 12. We're going to strike that sentence on page 7 of the bill. The county attorney shall commence an action when directed by the governor, Supreme Court, or legislature. All in favor, say aye.
Aye.
Those opposed, no. No. I think the ayes have it. Not a very strong vote, I might add, committee. It was not very robust. Further amendments on page 7. Page 8. Page 9. Page 10. Page 11. Page 12. Page 13. Page 14. Page 15.
Mr. Chairman.
Mr. Vice Chairman.
Thank you, Mr. Chairman. I'd like to propose an amendment to change the order of succession here from having the Attorney General in front of the Superintendent of Public Instruction to behind, so renumbering that to have State Superintendent on Romanet 6 and then Attorney General at Romanet 7.
Is there a second? I'll second for discussion. Representative Vice Chair, discuss that.
Thank you, Mr. Chairman. The reason that I'm bringing this amendment is simply there is more precedent with that existing office than there is for the Attorney General's office. And so be it that this office has existed for longer and that the public is more familiar with what this office does, that in a situation where the governor was no longer able to fulfill their duties, that this existing elected office would precede the new elected office of Attorney General.
Representative Chesty.
Thank you, Mr. Chairman. I would argue against this change. For one thing, given that these offices turn over fairly frequently, you're going to have a lot of new people in these positions at different times. So it's not the age of the office that matters. It's the age of the, or it's not the, how long has that been that office been in the list. It's how much experience does that person holding the office have that makes a difference. So I'm not persuaded by the fact that this is a relatively new office makes it less important than other offices. That doesn't persuade me. But also, I think the Attorney General has a much more broad purview about things that they're concerned about and have to know about in order to do their jobs. State Superintendent of Public Education, great office, great person, but they're focused on education. The Attorney General has a much wider lens, and therefore I think would have a much broader view of what the governor's office would have to do if they have to step up to it. So I oppose the amendment on that for that reason.
Vice Chairman.
Thank you, Mr. Chairman, and I do appreciate that previous comment. I would say that if I'm understanding the bill correctly, that this would not, in the way it's currently written, the bill would not introduce the Attorney General into the State Investment Board. Is that correct? No, I'm not correct in that. All right, disregard.
All right. Further discussion on the amendment? Pierre, do you have the amendment? I'm just gonna move the Attorney General from line 2 to line 6 and renumber. Committee, everybody clear on what we're voting on? All those in favor of Vice Chairman Singh's amendment, say aye.
Aye.
Those opposed, no.
No.
That amendment has failed. Further amendments on page 15, page 16, 17, maybe page by page wasn't a great idea, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34. All right. No further amendments, comments, discussion by the committee. Representative Chesty.
Thanks, Mr. Chairman. I will be a no on this bill. I was concerned before the testimony, and now after hearing the testimony, I'm even more concerned about the possible politicization of this office. I don't know what's broken with the current system. I think the current system works fine. And all this does, the fix is to put more politics in and create a hydra-headed monster at the top of the state, where we're going to have conflicts between who represents the state, the governor or the attorney general. And I just see nothing but problems with that. And therefore, I am opposed to this bill.
Further comments, discussion? Representative Kelly.
Thank you, Mr. Chairman. I'll be supporting this. I was listening this morning for the downside of having an elected position here. And the consensus of those opposed to it is that this would introduce politics into that position. And my understanding is that means it's introducing the will of the people into this, and then people deliberate and argue. And the idea that the governor and the AG might disagree is not necessarily a bad thing. And if we hold true that the argument is that the AG should be beholden to the governor, then I'd imagine the other members of the executive branch should be too, for the same reasons, because the superintendent or the secretary of state might disagree with the governor at that point. That has not necessarily been a bad thing for the state. And overall, the purpose of having this republic is to represent the desires of the people who live here, not necessarily be the most streamlined or efficient or quickly moving body, but to be the most responsive to the populace in general, which can be messy.
Further comments? Okay, so when I listened to this debate this morning and read through the bill, the couple of issues really stood out for me. One was the risk of a divided voice. We had this debate in relation to another executive office last year about initiating legal actions independent. And I can see both sides of that issue, but who really speaks for Wyoming? And it seems to me the governor has to be the voice of Wyoming. And an elected AG, I think, serves to undermine that. I also think that adding a sixth person to the five-person policy structure that we have now, the increased likelihood of tie votes, perhaps on important issues where it's 3-3 and it just dies. Everything dies because it's a tie, right? And so that worries me. But also the dilution of power. That if you're one of five or you're one of six, if you're one of six, you have less power than when you had one of five votes. And so I think by adding a elected attorney general, you dilute the power of the other five elected officials in the state. And so for those reasons, and also my concern about campaign finance, we're seeing an increased, presence of dark money, out-of-state money, influencing campaigns in Wyoming. And it does worry me that an elected AG would be potentially beholden to campaign finance support that comes from, other places. And that, so while certainly the people get to vote, their vote will often be swayed by the advertising and so forth that takes place during the course of a campaign. And who has the most money to get that messaging out there has a big impact on how the people of Wyoming view that race. And so for that reason, I'm going to be a no vote on this bill today.
Mr. Chairman.
Mr. Vice Chair.
Thank you, Mr. Chairman. And just to kind of follow up on that thought, I am concerned about the consolidation of power into limited amount of positions and whether or not these positions are able to wield their power in political conversations that carry a lot of financial backing as well. And I mean, we're all concerned about the influence of outside money in elections. And I just reflect on this last race where our chief executive formed a political action committee funded by tech money from outside of the state and tried to sway the voice of the legislature through individual endorsements. And so that, by having more positions in the executive branch where individual citizens are able to voice their concerns and where these big PAC donors are not able to funnel their money into one specific candidate, but rather they would have to compete, I think that actually enfranchises the individual voters more in the state of Wyoming, especially when our chief executive creates a PAC to specifically sway the legislature itself.
Representative Kelly.
No, thank you, Mr. Chairman. I just have to add on that I have to reject the argument that we have to protect the voters of Wyoming from themselves.
Okay. No further comments. Call the roll on House Bill 102.
Representative Brady,
Aye.
Representative Bratton,
Aye.
Representative Chestick,
No.
Representative Filer,
No.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
No.
6 ayes, 3 noes.
Thank you, Mr. Majority Floor Leader. You'll have it on the floor. Representative Knapp, any hope? We have to be on the floor at 9 o'clock. Why don't you come forward and have a conversation with us before we take up your bill? We're down to the deadline. For those listening, bills have to be out of committee by Friday. We have other bills stacked up here this morning, and we have more bills stacked up for Friday. Obviously, we're not going to get to all of those. So those of you coming into the room wanting to be part of the discussion on, or watching the committee work, our unfinished work on House Bill 194, it's highly unlikely that we're going to attend to House Bill 194 this morning. I set our meeting to start at 7, and then we announced that the body is going to gavel in at 9 o'clock this morning. So instead of having 3 hours, as I anticipated, we only have 2 hours. So on House Bill 280, before we take that up, let's just have a little conversation, Representative Knapp. Do you think there's any hope that this committee can work this bill effectively in the next 20 minutes?
Mr. Chairman, that would be my hope, is that you could work this in 5 minutes for approval.
Some people are delusional. All right, committee, we'll take up House Bill 280 and see how far we got. Representative Knapp.
Mr.
introduce your
Chairman.
bill and tell us what we need to know.
Mr. Chairman, thank you. Members of the committee, I'm Representative Chris Knapp from House District 53, and before you today is House Bill 280. This is a constituency bill that I brought several years ago. Made it through the House pretty overwhelmingly, got stuck up in the Senate, and worked with the AG's office on making this bill better and more manageable. The bill basically deals with a tool, and that tool is a sexual registry list for Wyoming. And I always view that as a tool because it sheds light for what would possibly be future victims of a sexual predator. And so that list allows people to look when they get into a new relationship, when they have a family. It gives them the capability to look into the future. So this bill basically takes the top offenses for sexual assault, so first degree, second degree, or with a minor, and makes that unable to remove yourself from the registry. The registry is for a lifetime, but you can petition to get off the registry at certain levels, 10 years, 25 years. This bill would make that not possible. So to give you an idea, right now, under the list for Wyoming non-removal of the sexual registry, when sex offenders don't comply with registration requirements, when they,
Representative Knapp, let's be clear. It's a sex offender registry, not a sexual registry. All
oh,
right,
I'm sorry.
please.
That's an important word to include in there. Thank you, Mr. Chairman. So there's several items on the list of non-removal, and this basically recategorizes some of the sexual offenses of first degree, second degree into that category that has that capability of not being removed. So the reason I have this is because unfortunately statistics show that the longer a person has been out since committing, the higher the recidivism rate. So in other words, after 5 years, the recidivism rate is actually 22%, which is a very high rate of recidivism. And in my mind, that's for the people who got caught reoffending. So if you can extrapolate that percentage by the people that don't, it's a very high recidivism rate. With that, I would take questions from the committee.
Questions from the committee? Representative Knapp, these are always complex bills, or not, they're difficult bills because everything in the sex offender registry references back to criminal statutes that fit into the different categories. And so to understand, you have to go back and keep refreshing your memory which crimes we're talking about in each of these categories. So can you give us some clarification as to which types of crimes you're wanting to recategorize?
Mr. Chairman, yes, we may go over the 5 minutes, but here we go. So, of course, first-degree sexual assault is one that is used by force or threat of force. The victim is physically helpless, mentally handicapped, and the defendant knows or reasonably knows that the victim suffers from such disabilities. Second degree would include the use of threat or reprisal against the victim's relatives or spouse. Submission by the victim to the defendant is obtained by means that disallows the victim the option of resistance. The defendant orders, directly administers a controlled substance to the victim without the victim's consent. The victim submits to the defendant because the victim erroneously believes the defendant is his or her spouse, and the defendant is reasonably aware of this. The defendant assumes a position of authority over the victim in a workplace or other environment. The defendant is an employee or worker in the county, district, or city, or works in any correctional or rehabilitative facilities where the victim is a resident. The accused works in an elementary school or secondary school, and by reason of such employment has interactions with the victim, who is enrolled at that school and is older than the victim by more than 4 years. Sexual contact, sexual intrusion is done on the victim by the accused when the accused, being a healthcare provider, is tasked with administering medical treatment and care to the victim. And finally, the accused subjects the victim to sexual contact, and in the process causes bodily injury in any of the instances mentioned above. So it's the first degree and the second degree, and those are the examples. It wouldn't take into consideration third or fourth degree convictions. Mr. Chairman, thank you.
Thank you. Representative Chestic.
Thanks, Mr. Chairman. I'm still a little confused. So it's the first and second degree charges that you're moving from having an opportunity to get off the registry to a category where they can't get off the registry. Is that correct?
Representative Knapp.
Mr. Chairman, Representative, that is correct. And I did this with the help of the Attorney General's office. So as Mr. Chairman noted earlier, it is very confusing to get into the statute and have that reference back. But that's why I used the Attorney General's office to help in drafting this.
If you need to phone a friend, I'm okay with that.
Further questions for Representative Knapp? Thank you. Ms. Chambers?
Thank you. Kara Chambers, Wyoming Attorney General's Office. I believe the representative clarified it. My office did review this and is fine, and I think he succinctly explained what it does. It moves the offenses that are currently in H to J, and for the reasons stated.
Ms. Chambers, how does this relate to SORNA? Are we compliant, and does this make us stand out as something different than other states?
Chairman Washit, the DCI who administers this didn't have any concerns with that.
Further questions? Representative Bratton.
Thank you, Mr. Chairman. How many or what percentage of offenses are we talking about here in Wyoming that this would affect?
How many offenders or how many offenses?
Offenders. Thank you.
Offenders, okay.
Offenders.
Mr. Chairman, if I could answer that for Representative Bratton. Currently in Wyoming, there's 2,586 registered. 590 of those are low risk, which would not be touched by this. 717 are medium risk, and 1,279 are high risk offenders.
Representative Chestic.
Thank you, Mr. Chairman. Again, I apologize if this is a dumb question, but we're getting a lot of things thrown at us very quickly and very little time to review things. So you're saying that we're moving those felonies from H to J, but what I'm not seeing any insertions. I'm just seeing deletions. Where is something, so what is H, what is J, and how? So we're deleting things from both sections, but I'm not seeing where we're adding anything.
Representative Knapp.
Chairman Wassett, Representative Testic, I believe what we've done is removed all the subsections and just consolidated. So everything under 62304. So, and then striking all of the subsections just to clean it up. And then 62317A 1 through. But again, as the chairman testified, it's so nuanced, it would take a really long time to explain it. But the overarching summary that the Attorney General's office and the Kelsey Singleton, who you might recall from prior testimony, is that we were just moving all of the subsections under sexual abuse of the first and second degree, which are currently under J, or under H into J. And so that means instead of having to check it in every 6 months, they now have to check in every 3 months. And as previously testified, they can no longer petition to be removed from the registry because what we had before is certain subsections. It was so striated. Certain subsections could petition for removal. And it was very nuanced, I guess is the word to say. You'd have to look at the specific crime.
But you see what Representative Chestic's getting at is there's no insertions. We're deleting language. How does that move something from one category to another category if we don't insert language someplace?
Chairman Wassett, there are, if you look on page 3, there are insertions of the entire section. Are you seeing on page 3, line 17, and on page on line 19, where we're just. You're welcome.
Thank you. That was helpful.
It's been a long day, I understand, already.
Representative Bratton.
So I just want to confirm that I heard you say that in addition to this, they'll be required to register it went from 6 months to 3 months that they have to, right?
Chairman Wassett, Representative Bratton, correct.
Representative Filer.
Thanks, Mr. Chairman. I was just wondering, because I had to step out of the restroom here, so I didn't get the whole testimony. But what is, I totally understand, make sure everybody's registering, stuff like that, but what's the difference between the 6 months and 3 months if nothing's ever changed? What brought this on is pretty much what I'm asking.
Mr. Chairman, thank you, Representative. The biggest thing that this does, not so much the check-in period, was the ability or the lack of ability to register, to petition to get off the registry. These higher level crimes are seen to be more at risk of recidivism. And again, it's not to punish the perpetrator, it's actually to be used as a tool for what could possibly be future victims if that person were to get off the registry.
Representative Filer.
Just to follow up, and with that, thank you, Mr. Chairman. So, because we got those different levels, right? So we're talking about 1 and 2. It's hard for me to make a real good educated decision when I don't know what the levels consist of, so it's probably something I'm gonna have to go through, but I totally understand it. But to say, we don't want anybody to be able to even petition a court to get off to having to register. Are we taking away, I'm not sticking up for anybody here, but are we taking away any due process here to being a United States citizen, to be able to clear your name or go through life and be able to, petition the court to maybe reduce a sentence or possible expulsion or all these other things? I don't know, because I'm not an attorney. Thank you,
Representative Knapp.
Mr. Chairman, thank you. Representative, in my mind, the registry exists for that very reason. The registry exists so that citizens have some mechanism to find out what crimes have been committed, and they're not those lesser crimes, they're heinous crimes. And I think it's the ability for those citizens to be able to just have that information and knowledge as to what they may be getting into in a relationship or a relationship with their children.
Representative Lean.
Thank you, Mr. Chairman. Thank you for bringing this today, Representative Knapp. My question is about the enactment date and why we have two sections there. The first one being that the act shall only apply to offenders who are convicted on or after the enactment, the effective date of this act. My question is, why would we not want to make this for those that were previously put on the registry list?
Representative Knapp.
That is Representative, or Chairman, Vice Chairman Singh, sorry. Representative, that is a very good question, and that's up to the body. If you have any comment to that.
Vice Chairman Singh, Representative Ling, that's an ex post facto issue. So once this goes into effect, that those who are now charged under the offenses that would require the higher registry are aware of the punishments that attach to it. However, those offenses that are in H and remain in H, nothing changes for those, but that's why the separation.
Committee, any further questions? Okay, anybody else in the room wishing to testify on this bill? Please come forward. We're at 8:50. We have to be on the floor at 9, so just so you know. Ms. Burlingame.
Good morning, Mr. Chairman. Good morning, committee. I will speed through this. I'm Sarah Burlingame. I'm the Executive Director of Wyoming Equality, and we are in support of this bill. I'm happy to email you some of this information so that you can look at it. I won't take your time reading all of it. But LGBTQ youth are disproportionately affected by early childhood sexual abuse. The National Health Library of Medicine says that sexual minority individuals were on average 3.8, 1.2, 1.7, and 2.4 times more likely to experience sexual abuse, parental physical abuse, or assault at school. And it goes on to state that due to these abuses, the resultant mental health leads to all kinds of problems later in life that you can imagine and that are true for any community. But due to the outsized nature that sexual abuse has on LGBTQ youth, we would support this bill, and we'd be happy if you guys took a look at some of the information, because we believe what it does is correct some of the misinformation that we've heard about LGBTQ individuals in Wyoming being perpetrators, and correctly restates that actually we are more likely to be victims, and bills like this do something to address and recognize the fact that vulnerable youth deserve protection as well. And I would stand for any questions, Mr. Chairman.
Thank you. Appreciate you being here. Questions? All right. Thank you very much.
Thank
Anyone
you.
else in the room wishing to testify on 280, House Bill 280? Seeing none, anybody on Zoom who's complied with the registration? No? All right. Yeah, he did not acknowledge, so we won't bring him in. All right. So with that, we're going to close public comment. Committee, what's your preference? Moved by Lean, second by Filer. Discussion on the bill or amendments? Won't go page by page. Any amendments? Question being called. Pierre, you want to call the roll on 280?
Representative Brady,
Aye.
Representative Breton,
Aye.
Representative Chestek,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lee,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
9 ayes.
More than 5 minutes, but we got it done. So thank you very much. All right, folks, we're out of time. I'll have to give some thought to House Bill 194. We are jacked up for Friday, and Friday is our last day to deal with bills out of this committee on the House side. So I will consult with my vice chair and we'll come up with a plan on where we go from here. But thank you all for being here, and I apologize for those who got up early and came down here and were ready to testify or watch us work on 194, and we didn't get to it. So the nature of a citizen legislature, right? You always have way more bills than we have time, and you have 62 idea machines sitting in the chamber, and we always generate way more bill drafts than we can possibly consider. So we'll do our best, and the Vice Chair and I'll come up with a plan for Friday. Thank you very much for being here. Pierre, thank you.